Yes, good morning everyone. Okay, so 21st January 2022. Let's see which are the important articles from the Hindu newspaper relevant to our examination. Look at the first page. Supreme Court upholds OBC quota in NEET examination. Okay, so this is important development from polity perspective, the reservation, what Supreme Court has said in this particular case. The observations of the judges are very much important, not only from prelims and mains perspective, but also from interview perspective. Many times the panel may ask question whether the reservation should be given, whether the Supreme Court judgment is correct or not. You should be aware about the arguments given by the Supreme Court. I will read those to you when we will discuss this article okay, separately. Yes, but it is important from polity perspective. Next, come to page number 6 directly. Yes, yesterday I told you that there will be some kind of article discussing about those IAS cadre rule changes. So there is lead article, drop the IAS cadre rules amendments. So this article, although it is written by former IAS officers, okay, so it is actually talking about the problems with these changes, okay, and why it should be and it should not be implemented. So we can say that the decision is criticized in this article. Okay, so yes, it is important from polity perspective. Also, those who are having a public administration optional subject, for them also it is important. On left hand side, court and compensation. So yesterday we were talking about Supreme Court taking into its own hand the compensation process. It directed some of the states who were delaying the dispersal of the compensation or ex gratia amount to the relatives of those who died because of COVID-19. Okay, so this article again discusses that issue. We will discuss that again. Okay. Now next, look at the page number 10. Two important articles. Extended range of Brahmos or extended range Brahmos test fired. Okay, so Brahmos missile, a few days back also there was we can say testing of Brahmos missile from INS Vishakhapatnam, if you remember. Okay, so early this month we had discussed that particular topic also. On top side there is one article, Environment Ministry plan to rank states draws ire. Okay, so there is criticism by environmentalists. This particular initiative by Environment Ministry, which seeks to let's say create kind of competition among the state environment impact assessment agencies by rating them on the basis of, we can say, some points are given, stars are given for early completion of the process of approval to the different projects, EIA approvals. Okay, and the environmentalists are concerned here. They are saying that such kind of hasty process may go against the environment law principles. Okay, so we will discuss that from environment perspective here, GS3 paper. Okay, so yes, these are the relevant articles. Let's discuss them in detail. First article, lead article on page number 6, drop the IAS cadre rules amendments. So the context here is recently the central government had, or DOPT had given the notification, or we can say that the changes that are proposed to IAS cadre rules 1954 dealing with the deputation of all India service officials. Okay, so and the replies or the views of state governments are sought before 25th January 2022. Okay, so this is the context, but what are the present rules and conventions followed on deputation? Presently, we can say that there is consultation process, healthy consultation process which is followed, consultation between center, state and official itself. and then only the decision is taken on deputation. Second thing we should be aware here is that no deputation is done without or against will of officer. That means only if officer agrees for deputation, then only the deputation is done here. Third thing we should understand that whatever the list every year select list of officers is given to center, and center select those officials from that list. Okay, that means the process is voluntary on behalf of state, and there is no we can say forceful actions by the central government. Rather, central government select from the given list by the state. This is the healthy process that is going on at present in the country. But now what are the changes proposed and how they impact? We will analyze that. Okay, so four changes have been proposed to Rule 6(1) of this IAS cadre rules 1954. And among those four, two rules are, let's say, being criticized by the state governments. First, making it mandatory for state government to provide certain fixed number of IAS officers for central deputation every year. So it is some kind of, let's say, compulsion. It is some kind of compulsion on state governments. First thing. Second rule which is criticized is provision that requires state government to release such officers whose service may be sought by the central government in specific situation. Now this can be arbitrarily used by the central government. Simply suppose the chief secretary in a particular state is forced to depute to the central government. What will happen to the state government then? Because chief secretary is most important, we can say, civil servant for we can say IAS officer in the state, and he is responsible for a complete administrative structure there, and suddenly suppose that person is asked to withdraw from the state services, or let's say service to the state, and deputed to the central government. Recently such kind of case happened with West Bengal. We discussed that in Hindu analysis. Okay, so what happened is, just before the one day of superannuation of that chief secretary of West Bengal, the central government asked for the deputation for that person or official. Okay, and one day after he was going to retire. This controversy was created at that time, and later on that, let's say, official, after retirement from the civil services, he was appointed by the Bengal chief minister, West Bengal chief minister, as a personal secretary. This is how the conflict happens due to political considerations. Okay, so this can be misused, and this is the major concern. Then in analysis we should also understand it affects the independence. It affects the independence, and we can say security of civil servants. It affects independence and security of the civil servants. Civil servants do not know whether they will be serving the state or serving the central government. Okay, so this affects their independence also. The kind of neutrality and anonymity they needs to follow, it may be affected. Okay, so the civil servants may start thinking about giving some kind of edge to particular political party or the government. Why? Because they will think that it is favorable to them. It will provide some kind of security of the tenure, or simply we can say that it will provide them the longer service in a particular cadre. So this is how the independence and security is affected. Next thing we should understand here, that although the argument by the central government for such changes is the central government is facing crunch of IAS officers, or simply we can say all India service officials. But the major reason here is that central government itself is promoting central services on deputation rather than IAS officers. Okay, so central services officers are more given the deputation in the ministries. Second thing we should understand is that the central government is promoting lateral entry, which is to some extent affect morale of IAS officers, because the lateral entry is directly at the higher official levels, no? So this is affecting the morale of the IAS officers, so that's why they do not opt for deputation, rather they will focus on serving their own cadre. Okay, so the government should focus on these problems first, central government, and then automatically whatever the voluntary pool is available, the central government can select from them, and we can say such kind of changes are unnecessary, or the compulsion should not be there. Simply there should be some kind of whatever the principle of cooperative federalism enshrined in our constitution. From time to time Supreme Court, or if let's say Supreme Court in many judgments, it has said that the center and state should follow cooperative federalism, along with that constitutional morality. These principles should be followed by the center in letter and spirit. Then only the administrative machinery will be stable, it will work in consonance, and there will be some kind of stability in the administration. Okay, so this can be the way forward ultimately to resolve this issue. Okay, you should be aware about the present process, the changes proposed, and its impact, and the way forward. Straightforward question can be there, and you try to attempt such question here. Okay. Yes, of course, the personnel in the states or those cadres will reduce. Also, this will demotivate the state government to draw the IAS officers, or they will focus on state services only. So they will try to cover as many as the positions by the state service officials only. They will not be dependent on the central government for those IAS officers, IPS officers.
Sir, it may give the negative feedback of IsCADA also, in the open public.
Yes, that's why it affects the morale of motivation and morale of the civil servants here. All these aspects are relevant. Okay. Yes. Now, court and compensation. Yes. Simply yesterday there was judgment here or order by the Supreme Court talking about, let's say now it will oversee the COVID-19 compensation process. Why? The reasons is in some of the states there has been delay in dispersal of ex gratia amount to the kins, or simply we can say relatives of those died in the COVID-19 pandemic times. Okay, so here in the latest hearing the Supreme Court had to pull up the couple of states for not dispersing the amount fast enough and express concern about high number of rejected claims. Okay, in recent past the bench had passed the orders to effect that no person's family shall be denied the benefit on the ground that death certificate did not specify the cause of death as due to COVID-19. Now, why Supreme Court had given such kind of order? Because there were many cases where the hospitals were not giving the appropriate certificate. Even those who died because of COVID-19, but they had some kind of comorbidities. There were the cause of death mentioned was comorbidity rather than COVID-19. Okay, suppose a particular person is having TB and suppose he is infected, so obviously there are more chances of death there, but here the reason mentioned on that certificate is TB rather than COVID-19. Now that person is not eligible if we are talking about a literal process. Cause of death should be COVID-19, certificate should mention that, and many such cases appeared, and now Supreme Court had said that such kind of benefits shall not be denied to the person's family even if the death certificate is not specifying that. Then the court directed that any death occurring within 30 days of person testing positive or being clinically determined to suffer from infection will be eligible for ex gratia payment. Now why such thing 30 days? Because what happened is many people died after getting infected after so many days, and they were COVID-19 negative at that time when they died. But the kind of impact on the organs of the body happened because of COVID-19 infection, that was not considered in that certificate. Of course, we should understand that the main reason is COVID-19. Okay, and that's why this 30 days criteria is considered here by the Supreme Court. Now, recent order, yesterday's order, the court has directed that officials reach out to the families on their own. Now, this kind of, let's say, rejected claims or the deaths, simply we should understand that the amount dispersal has not been in consonance with the number of deaths. This shows that the administration is not proactively reaching to these families. And in a welfare function, it is expected that the government should reach out to those families in distress, as the sole bread earner of the family has died. So simply these families may be in distress, the government should proactively reach out to these families to provide that ex gratia amount. Now Supreme Court has ordered or directed like that. Also it has mandated the disclosure of the reasons for rejection to the applicants so that they could either rectify errors or go on appeal to the committee to redress such grievances. At district level, the committees are formed to redress the grievances of these people to receive this ex gratia amount. Okay, so this you should be aware about the compensation process and how Supreme Court from time to time has intervened. First of all, it had to persuade and pressurize central government to provide ex gratia amount. After that, the process started, the amount was fixed by NDMA 50,000, and then the dispersal, there is a delay. Then there are inclusion exclusion error, the problem with the certificates, all these came in, and again Supreme Court intervened from time to time.
Sir, I have one doubt, sir. Already these are infected by the COVID, they are already registered by the Aadhaar card, sir. Aadhaar card has been linked with the direct bank account of that particular person. If the death certificate claim, automatically Aadhaar card will be deactivated by the government official in municipality area or like that. Those are directly claimed to that one. They have the option to direct DBT option, and then why should they are going to be depending on government officials?
No, see, the person died, no, so why to give the amount in his account or her account? Simply it should go to the family, no. Again family will face problem to get that amount from the bank.
Already, sir, because of the family are already existing, linking of Aadhaar card, within the, if they are died, automatically they will get the information through Aadhaar card analysis. But when the government is going through this channel, it's a proper way to getting the benefit to the died person families. But
Yes.
the government is asking mandatory to go field work.
Yes, it is asking people, it is asking those family members to come up with that certificate instead of proactively reaching out them. The government is having all data. Simply we should understand. The government is having data related to infections, those who died also, their contacts, everything they know, but still they are waiting and they are waiting for those families to come forward and receive that, show the certificate. That means it is already they are facing distress, these families, and further the burden is added on those families. That's why Supreme Court is concerned here. अगर ये प्रोसेस थोड़ा अच्छा कर देते वो, ठीक है, थोड़ा सा हैसल फ्री करते, ठीक है, तो भी प्रॉब्लम नहीं होता. बट द प्रॉब्लम हियर इज दैट ऑलरेडी दे आर फेसिंग प्रॉब्लम एंड यू आर फर्दर इंक्रीजिंग प्रॉब्लम्स. ठीक है.
In my state, sir, AP government, sir, is a local voluntary system in there. If any person has died, automatically they will come to in front of home. They will upload that person in Aadhaar card. Directly it will go to state government and central government. It will lead to that person Aadhaar card. So that person. That system will be very fast and efficient manner.
Yes. Simply, how many people, how many families will be there? Try to understand. Okay, so those who died, reach out to those families. No, it is very simple and it can be done in very fast manner, proactive manner. तो ये unnecessary delay हो रहा है, right? Next, Environment Ministry plan to rank states draws ire. Now, what is the proposal? First of all, understand that proposal. A note to states by the Union Environment Ministry on 17th January spells out 7 criteria to rate state environment impact assessment agencies, state EIA agencies, to transparency, efficiency and accountability. Okay, so on a scale of 7, this particular authority of state, for instance, gets 2 marks for granting a clearance in less than 80 days, 1 mark for within 105 days and no mark for more. तो ऐसे क्राइटेरिया दिया है उसमें. Okay, now this may lead to a competition among the states. It may lead to a competition among the states or these agencies to provide early approval to get more stars. Okay, to get more stars here. And simply we should understand EIA agency with score of 7 or more would be rated 5 star. Okay, so just it is a recognition by the central government or Ministry of Environment of these state EIA agencies. Now, ministry officials says that the ranking criteria was not intended to accelerate the speed with which the clearances were accorded, but to encourage these agencies to take quicker decisions on approving or rejecting projects and adhere to the timelines already specified by the provisions of Environment Impact Assessment Notification, or simply we can say the Environment Protection Act 1986. Okay, but थोड़ा सा contradictory statement लग रहा है, right? So they are not saying here कि to accelerate the speed with which clearance, and the second part you see to take the quicker decisions on approving or rejecting project. तो उसी को तो बोलते हैं कि what you can say, speeding the approval process. It is going to make some kind of errors. Okay, the speedy or hasty decisions may let's say leave out some kind of dimensions involved in EIA, Environment Impact Assessment. Already draft EIA notification 2020 created many problems. It was criticized on many fronts, and later on the decision is still pending on that. UPSC asked question on that particular topic last year in 2020 mains examination. They asked the comparison between the existing EIA notification 2006 with the draft EIA notification 2020. So again, this such kind of, let's say, initiatives by the central government or Ministry of Environment are to some extent violative of environmental principles or law principles. Okay, by stressing quick and efficient clearance, the process undermines scientific rigor in decision making process. Right? So,
in this environmental impact, it may depend on the fast approval and fast rejection. It may lead to faulty data uploading as well as the
Yes,
processing. It may
there are chances of error. Yes, yes. That's why environmentalists are concerned about it. Okay.
it may lead to long time impact on environmental as well as the humans also, the surrounding
Yes,
environment
of course,
area.
of course. So if all dimensions are not considered, such kind of projects may have the negative impact on human also. It may result into any kind of disaster also.
Example, the Delhi dam has been construction. They given a very fast manner of clearance. If the private companies will start the construction and everything, sir, it may lead to that surrounding area will get affected in long time period.
Yes, yes, yes. Of course, of course. Now, extended range Brahmos test fired. Yes, supersonic cruise missile Brahmos with increased indigenous content and improved performance was successfully test fired from the integrated test range Chandipur in Odisha. This missile was equipped with advanced indigenous technologies and followed a modified optimal trajectory for enhanced efficiency and improved performance. Now, earlier this month, extended range ship-to-ship variant was test fired from indigenous guided stealth missile destroyer INS Vishakhapatnam. We had discussed this particular, let's say, news earlier this month in the Hindu analysis. Ship-to-ship variant of Brahmos cruise missile. Okay, the missile is capable of being launched from land, sea, sub-sea, and air. Okay, so against surface and sea based targets, and it has been inducted by Indian Armed Forces. It was recently news because it is going to be exported to Philippines. Recently Philippines agreed to buy this Brahmos from India. We had discussed that news also.
First time in India they are supplying the arms
Yes,
weapons to other countries.
Brahmos missile. Yes, yes. Okay, so remember that it is cruise missile, not ballistic missile. Cruise missile moves near to the ground and it becomes, let's say, it is maneuverable. Simply we should understand. And ballistic missile is like a test. Once you fire that and you cannot maneuver that, and it follows a parabolic path, the ballistic missile. Okay, but this cruise missile can be maneuvered and it is difficult to detect because of such kind of nature. Cruise missile. Okay, fine. Yes, and lastly, the Supreme Court uphold OBC quota in NEET examination in all India quota seats for this NEET for undergraduate as well as postgraduate medical and dental courses, and said that reservation is not at odds with merit in open competitive examination. Okay, so a very good observation made by Supreme Court. I would like to read that to you. It can be used in essay paper or mains GS2 paper polity part, or in general to give the argument whether such let's say quota should be given or not, and whether merit is in some kind of, let's say, opposition with the reservation. A reservation is opposite to merit. ये argument होता है ना हमेशा, right? So let's understand what they are saying here. Yes, the privileges that accrue to the forward classes are not limited to having access to quality schooling and access to tutorials and coaching centers to prepare a competitive examination, but also includes their social networks and cultural capital. Okay, so what is that social network and cultural capital they are saying? Those who are from forward, let's say, caste, they have some kind of, let's say, their family background, which is to some extent favorable to make decisions by the children in the early age itself. Okay, so families and the parents, grandparents, they guide the children they make them aware about the opportunities in front of them, how to, let's say, pursue those opportunities. Everything is told to them. Okay, and this is not available to the, let's say, children or aspirants from the backward classes, because they are first generation we can say receiving the education, and that's why they are not aware about the opportunities. Try to understand this. They may be having some kind of access to the coaching institutions or something like that, like the other students, but they take the decisions in a delayed manner. Okay, or maybe they are not aware about all opportunities, all the things, and that affects their decision making. The cultural capital ensures that child from the forward classes is trained unconsciously by the familial environment to take up the higher education or higher post commensurate with their family standing. That's why हम देखते हैं ना यूपीएससी में भी IAS ऑफिसर्स, सो IAS ऑफिसर्स या IPS ऑफिसर्स के उनके बच्चे भी IAS ऑफिसर बनते हैं, IPS ऑफिसर बनते हैं largely, right? So there is some kind of family background to them, right? So this is the situation common with all other sectors also of education. Along with that, the let's say other argument related to merit here, the merit is not solely of one's own making. The rhetoric surrounding merit obscures the way in which family, schooling, and fortune and the gift of talent that the society currently values aids in one's advancement. Thus, the exclusionary standard of merit serves to denigrate the dignity of those who face barriers in their advancement which are not of their own making. Rather, it is societal, no? Whatever the barriers are there, they are societal barriers. So, the Supreme Court has said that the idea of merit based on the scores in an examination requires deeper scrutiny. When we say in an objective manner, merit means the number of marks. जैसे UPSC में मेंस एग्जामिनेशन, प्रीलिम्स एग्जामिनेशन, number of marks you received, that is merit. There is cut-off list. Okay, but the broader analysis, if we do that analysis of merit, it requires deeper scrutiny. This is what Supreme Court is saying. While examinations are necessary and convenient method of distributing educational opportunities, and marks may not always be the best gauge of individual merit. Okay, if a high scoring candidate does not use their talent to perform good action, it would be difficult to call them meritorious merely because they scored high marks. The fortitude and resilience required to uplift oneself from conditions of deprivations are equally reflective of individual caliber and merit. Are you getting this? So they are considering the attitude of the person, the perseverance of the person, and simply we can say the never say die attitude they have towards achieving some goals in the life, that is also part of merit. सब कुछ स्पून फीडिंग से मिला है और आप फर्स्ट रैंक आ रहे हो और उसके बाद आप अच्छा काम भी नहीं कर रहे हो, अगर एग्जामिनेशन के बाद में भी, ठीक है, या अच्छे डॉक्टर भी नहीं बन रहे हो. सपोज अ पर्सन गेट्स रैंक फर्स्ट रैंक इन नीट एग्जामिनेशन एंड दैट पर्सन इज सेल्फिश डॉक्टर, सपोज he becomes the selfish doctor. Now that person will not be meritorious person even though that person is getting the first rank. Are you getting this? So this can be asked in ethics paper also, such kind of analysis. You should be aware about arguments here.
Education without morality will not be there.
Yes, yes. So simply they are talking about why this reservation should be extended to the OBC in all India quota seats. Up till now they were not giving to the OBC. Okay, SC/ST quota was there, but recently the government had given that OBC quota, extended that OBC quota, and there was let's say widespread protests. Okay, so now the Supreme Court has taken the stand in favor here and said that reservation is not at odds with the merit. Fine. Yes. So what should be answer to this question?
True only, sir. It's a cruise missile.
Yes. So Brahmos missile, the correct statements we have to find. It is a ballistic missile. No, it is not ballistic missile. Rather, it is a supersonic cruise missile. Okay, there is difference between ballistic missile and cruise missile. Just now we have understood. Also, you should be aware that it can be launched from land, sea, sub-sea and air. Sub-sea means from submarine. Okay, it can be launched from the sub-sea platforms or simply from the submarines also. Okay, so this is correct statement. So 2 only is the correct answer here. Fine? Okay. Any question?
So I have a general note, sir. Those are belongs to OBC. That person will get the EWS quota also, or only he will get OBC, sir?
Only OBC, no? EWS is for general category students.
Okay, sir.
Okay?
That I have a little bit confusion for that one. Whether we need to apply EBC or OBC.
No. So those belong to general category, they can apply from EWS category. So having some income certificate they provide there. And those belonging to OBC, there also creamier, non-creamier criteria is there. So particular income amount above that they will be considered creamier. They will not get the reservation. Okay.
Thank you, sir.
Yes, fine. Let's stop then.